Dear professional friends, welcome to 9th episode of GST Weekly Updates. We are excited to see your overwhelming response on our last episode. Thanks for the same. There is no new notification, circular or clarification issued by the department between last episode and this episode. Keep watching till end. Before end, we will take all queries, questions received by us during this period. Let's begin with critical case laws that are important for you, your client, and for your businesses. Let's dive into a significant 2024 ruling from Allahabad High Court involving Atracycle Haryana Limited versus State of Uttar Pradesh, reported in 2024 NTN Volume 84, page 544. This case focused on the critical aspect of natural justice in GST assessments. In this very important case, Atracycle challenged an adverse GST assessment order, claiming it was passed without giving them an opportunity for personal hearing, a fundamental right under GST Act. The crux of dispute revolve around whether the principle of natural justice as specified in GST Act specifying the opportunity for personal hearing was violated under section 73 and 75 of CGST Act. The court observed that the notice issued to Atracycle did not specify any date for personal hearing, and the space for date of personal hearing was marked NA not applicable, effectively denying them the opportunity to orally present their case. This was concluded by the court that denying Atracycle a personal hearing was against the mandatory procedural requirement under the CGST Act, violating the principle of natural justice. The court's decision emphasizes the importance of allowing taxpayers to present their cases fully, both in writing and orally, before making any adverse assessment. This ruling set a precedent for the rights of taxpayer during the GST assessment procedure. The Allahabad High Court's judgment in favor of Atracycle Haryana Limited reinforces the fundamental principle of fairness and transparency in tax administration under the GST law. Now let's examine a 2023 landmark decision by Bombay High Court in case of IMS Ship Management Private Limited versus State of Maharashtra, reported in 2024 NTN Volume 84, page number 540. This case addressed the timely issue of appeal limitations in GST law. IMS Ship Management challenged an Appellate Authority's decision dismissing the GST appeal as delayed. The contention was whether the appeal was indeed delayed, considering the date the petitioner became aware of the order. The core legal question was whether the Appellate Authority should have dismissed the appeal based on delay without thoroughly examining the petitioner's argument regarding the actual receipt of date of order. The court scrutinizes the lack of consideration by the Appellate Authority for the petitioner's submission, which claimed the appeal's time should start from the date of they gained knowledge of the order, not the order's issuing date. The High Court found that the Appellate Authority decision was unjustified as it failed to consider the petitioner's reason for the delay, rendering the dismissal as procedural flawed. The ruling underlined the necessity for appellate authorities to meticulously review and reason their decisions on procedural matters like timing of appeal, ensuring justice and fairness in the legal procedures. The Honorable Mumbai High Court's judgment highlights the critical role of detailed judiciary scrutiny in upholding the principle of justice, specifically in procedural aspects of law litigations. Next to discuss is an important 2023 decision from Mumbai High Court in Tribest Fine Yarn Limited versus Union of India, reported in 2024 NTN Volume 84, page 531. This case focused on the procedural aspect of time limitation in GST appeals. Tribest Fine Yard Limited appealed against a GST decision, but the Appellate Authority considered the appeal time barred and yet proceeded to assess the merit of the case. In the heart of this case was whether the Appellate Authority should have been proceeded to decide on the merit of appeal it deemed time barred, a significant procedural question under GST law. The court scrutinized the Appellate Authority's approach, finding it contradictory to decide on the merit of the appeal already considered time barred. The proper procedure was questioned, essentially regarding the adherence of statutory timelines. The Honorable High Court ruled that it was inappropriate to decide on the merit once the appeal was dismissed time barred, leading to the setting aside of this order and remanded the case for the fresh assessment. The judgment stressed the importance of clear procedural adherence in the legal processes, particularly emphasizing that appeals should only be assessed on the merit if they meet the necessary statutory timeline criteria. The Honorable Mumbai High Court decision in this case reinforced the principle that legal processes must be consistent, transparent, and strictly adhere to the established timelines. Now let's explore 2023 Madras High Court's ruling in case of TVL Raja Stores versus Assistant Commissioners ST, reported in 2024 NTN volume 84 page 526. This case deals with the contentious issue of GST audit applicability on closed firms. TVL Raja Stores was subjected to a GST audit for the period it was operational, despite the business having closed. The store contested the audit, arguing that a closed firm should not be audited under Section 65 of CGST Act. The important question was whether the tax authorities could audit a firm for a period when it was operational but now closed, focusing on the interpretation of registered person under Section 65. In this case, the court examined the language of Section 65, which allow audit for any registered person. The court interpreted this to mean that the only active registered businesses should be audited, not those have been closed operation-wise. The Honorable Madras High Court decided that conducting an audit on a closed business was not in line with Section 65, leading to the question of the audit order under TVL Raja Stores. This judgment clarified the scope of tax authorities' power under CGST Act, limiting audit of the firm actively registered during the audit period, and underscore the protection of closed business from retrospective audit. This is an important case, and in this case of TVL Raja Store, it sets a significant precedent, highlighting the legal boundaries within which GST audit can be conducted, ensuring fairness and clarity in the tax administrations. Now let's discuss another important case of 2024 by Allahabad High Court in case of Visible Alpha Solutions India Private Limited versus Commissioner CGST Appeal Noida, focusing on the procedural aspect of GST appeal, reported in 2024 NTN volume 84 page 547. Visible Alpha Solutions filed an appeal against a GST order but faced dismissal because a certified copy of order was not filed with the specified within 7 days period, raising procedural questions. The case centered on whether the dismissal of the appeal for not submitting a certified copy within 7 days was legally justified, given the electronic filing was within the 3 months window. In this case, the court examined the provisions of Section 107 of the CGST Act and Rule 108 of the CGST rule, interpreting that the strict 7 days timeline for filing certified copy should not be overriding the substantial right to appeal. The Honorable Allahabad High Court quashed the Appellate Authority's order, directing a fresh hearing on the appeal on merit, emphasizing the need for a reasoned decisions within a statutory framework. This ruling underlined the importance of balancing procedural requirement with the substantive right of the taxpayer, ensuring that technical lapses do not unduly hinder the justice process. The Visible Alpha Solutions case reaffirmed the principle that legal procedures should facilitate justice, not act as barrier, especially in the tax appellate procedures. Now query time. We received multiple queries, but we request to write the query in detail and with clarity so that we can actually give the useful or fruitful reply to that. So the one query that we received is IGST has been wrongly claimed in 2017 as CGST and SGST. Can this error be rectified now? If yes, under which provision, and also suggest related case laws if any. So according to me, if the wrong credit has been taken as GST, wrong IGST credit has been taken as CGST and SGST in 2017, there is no possibility of rectifying it now, and there is no provision which allow you to do now, because there's a long time has been passed from 2017 to 2024. So this is not possible now. So you have to forego this. Second query that we have received is our supplier issue us credit note without a GST impact, so which reduce our purchase liability, and as a resultant we do not need to pay GST liability from cash account. And now GST department is raising a question that why you are not paying GST from the cash account, which mean overutilizing your ITC of the GST credit. In this case, the supplier has a right to pass on the GST or not to pass on the GST or reverse the GST on credit note based on the conditions under GST Act. If the reason of this credit note is discount or incentive or any other claim, and if it was not known to the supplier at the beginning of the period of the invoices under which the invoices are raised, he has the right not to claim the GST back. He cannot reduce his tax liability, which means you should also not reduce your ITC in that case. But this should not be a practice which becomes so big that you don't need to pay your GST. So prudence practice is that this has to be used judiciously so that the reasonable business margins are there with your organization and you need to pay GST on that amount. Dear friend, we received few queries which were difficult to understand. Please send us queries in such a way that we can read them, understand and reply them. Thanks for watching. Don't forget to like, subscribe and hit the subscription bell so you never miss out our latest videos. Please share your valuable feedback and ideas to improve, to make it more useful for viewers in the comment box. You can also ask the relevant case laws which can be useful for you. So keep agile till next week and stay connected for more such excited videos. Thank you.